Namaskar, this is Seshadri, your labor advisor, corporate trainer, POST IC. I am very happy to see you through this monthly HR statutory compliance video. Thanks for giving your support. Please watch till end. As usual, this video consists of May month statutory compliance training as well as last month, that is April 2025, what are all the circulars we received, as well as judgments came on HR topics. Let us start and enjoy this video. Monthly compliance, if you see this month, usual compliance like PF and ESI. For the month of April 2025, that is the wage month, for that ECR challan we should pay on or before 15th May 2025. As well as if you have any international workers in your organization, we need to file returns for international worker on or before 15th May 2025. In ESI challan for the wage month April 2025, we need to pay on or before 15th May 2025. Professional tax, in case monthly payment you need to make depends on your state. Yes, we need to make for professional tax also. As well as in ESI, the members who are coming out of coverage, that means their salary has increased more than 21,000. This month you have to remove their name by mentioning the in challan, and you are uploading the challan, you have to mention the date of living in this month only. Trainings, there are 3 trainings. One is in English Pan India, we are going to conduct on webinar only, that is MS Teams we are going to have, that is on social security benefit, that will be in English, that is Pan India. You can join anywhere, you can join full day course that consists of employee benefits, statutory benefits. What are all the statutory social security benefits we need to provide to the employees? PF, ESI, maternity, gratuity, bonus and leave. These are all the provisions in detail. We are going to see eligibility, how to calculate and how to pay. The complete understanding you will be having on social security benefit to the employees. This will be on 18th May in English. It is in MS Teams. As well as in Tamil, we are going to have one direct session at Chennai Hotel Kalyan on mastering the payroll process, statutory provisions, as well as the step by step and what are all the pay structures available in various industries. Those things will be the this workshop. As well as in Tamil webinar, one will be the Tamil Nadu Shop and Establishment Act and Contract Labor Act. Regarding that one webinar, on full day webinar on 25th May we are going to have. So whatever the sessions you want to join, please contact Mr. Dinesh. His number is given in the last slide. And we have sessions, 2-hour sessions, short sessions on webinar. The blue color, whatever is there in English, you can join the English session also in Pan India. As well as we have technical sessions also, 2-hour sessions. Whatever the sessions you want to join or you want to send your employees, please contact Mr. Dinesh. HR updates for this month. In Factories Act, there is an amendment in Andhra Pradesh. So you know very well, Factories Act is a central law, as well as the state for implementation, they have the rule. In that, rule 76B of Andhra Pradesh factories rules, in that deals with welfare officer appointment. In welfare officer appointment, there is a slight change in qualification. As of now, for appointing welfare officer in Andhra Pradesh, any degree in arts, science, commerce and law. Now it is going to be changed as any degree. It is approved by UGC. As well as the PG diploma, degree or diploma in with labor law, at present it is there. Now it is going to change as a PG degree or diploma with what are all the, it has been added, labor legislations, industrial relation, human resource and labor welfare. All the things should be there in that PG degree or diploma, then only he is eligible for appointing as a welfare officer. That is a draft rule. Maybe short notice they will publish in Gazette for implementation. Next, PF Form 13. So Form 13 is used for transferring the fund from one organization to another organization. When employee is joining or transferring, that time get back that funds from one organization to another organization. Form 13 is used. When it is used earlier, there was a lot of procedures, transferring office, transfer receiving office, both the office should check and approve. Now it has simplified, revamped, only transfer out office as to approve, transfer in office they can accept and credit in the employee's account as soon as the transfer out of is approved, it will be reflected in the passbook of employee. That much it is revamped now. Bulk UAN generation without Aadhaar, it looks something funny when you are seeing only without Aadhaar we can generate UAN. That is not. Only the organization who are from trust to they are coming back to EPFO or with the court on judgment, something bulk generation is required. That time, yes, even because of Aadhaar you cannot wait. It has been relaxed, for the provision has been made in the software itself. Then loans. In PF, when you are taking loan, various reasons you can take. 68B7, 68B deals with the advance for purchase of home, or for any repair also you can withdraw amount advance from your PF account. When you are withdrawing for repair of your house, there should be a minimum 60 months contribution in between first withdrawal and the second withdrawal. The amount how much you can get for repairing, 12 months basic plus DA, your basic plus DA as per PF 12 months, or what is the your amount lying in members share lying in the PF, whichever is less that will be given. Now the relaxation is given that 60 months contribution for dwelling house withdrawal, self declaration is enough. You need not to link anything earlier, how much, nothing is linked. Only self declaration is enough for the 60 months. That circular has been issued by EPF. UAN, the Umang app is there. Hope you may be aware of that Umang app. That Umang app we can generate now UAN number and then activate also. The activation also, one method is already through Aadhaar OTP. Now face detection. There is another app also, it is linked in the Umang app. With that you can by showing your face, your UAN can be activated. That's what another circular says. And now payment of earlier contribution, past contribution through DD, as of now it is not possible. Then there is a circular, yes, you can pay if field officer convinced. As well as the same circular advises, don't hurry in paying the DD, try in ECR only. It is still advised to pay through ECR even the old contribution, past contribution. If it is not possible due to various reasons, then convince your field officer and pay through DD. That's what this circular is saying. Then once the KYC, bank KYC approval, in that process there are two changes. One is you need not to upload check leaf or bank passbook when you are withdrawing any loans, because your KYC is approved by bank and EPFO, then that itself enough. Again need not to upload check leaf or bank passbook. That is the one thing. Another thing is employer approval is not necessary. So for bank approval, that account for seeding process, employer approval is not necessary. Automatically whatever pending available, automatically it will be treated as approved, because the account number whatever seeded, it will be go to bank, then bank will say yes, then only it is approved as a KYC. That's why employer, in between employer is removed. Their approval is not necessary. Judgment, we will see a lot of good judgments for knowledge. It has come. Madras High Court, there is a management of State Transport Corporation versus Special Joint Commission of Labour. In this, the inquiry, domestic inquiry has conducted because the employee conductor has not come for 10 days work without any information. Because of that, they conducted the inquiry. The employee also accepted, and then immediately he was terminated. The court has questioned the 10 days coming because he has not informed and absent. Is it the right punishment to terminate him because he has put 20 plus years of service in that organization? Just because 10 days not come, you cannot terminate. So that also the inquiry was hurriedly conducted. Only within the 6 days, the inquiry as well as the report, only 6 days only it has took. Immediately you have taken the decision. It looks illegal. That's what Madras High Court has given judgment. Like policy. So employee compensation policy we have to take, that very well. When the employees are not covered under ESI, we have employer is the responsibility to pay the employee compensation when anything happen during the work as well as in the course of employment also. Anything happen, employer has to pay. Thing is, here two things we have to say in this judgment. It is given by Bombay High Court, the managing director of Natural Sugar and Allied Industries versus Ramadan Jadhav. And in this security guard, the security guard was working in unit 1. He was posted to unit 2. He was on leave. After leave, he was coming back to duty. So near the factory, he met with another vehicle has hit him, and then he was injured and he admitted in hospital. In hospital, he died. The company has taken responsibility, has spent money for hospitalization, everything, but they did not pay employee compensation to him. They asked the insurance company denied because it was the insurance was taken for one unit, but he has died in another unit, so they will not pay. While taking the insurance policy also, we should be very careful. What are all the places you are going to depute your employees? There you have to mention in that policy. Otherwise, the insurance company say it is not, we can't pay. So the employee, in case of any dispute is there also, what employer responsibility, he has to deposit to the controlling authority, whatever the things, yeah, the authority, you have to deposit the amount. Afterwards, you can see whether it is payable or not, everything we can discuss. Both the things not done here by the employer. That's why court has ordered the employer has to pay employee compensation to the nominees. Another judgment, employer-employee relationship. When the contractor, one principal employee is there, he is the one-man principal employer, he is deputing the employees various places, the contract employees, all other things are complete. Because nearly the principal employer is ordering to come up various places, he is giving the work to the contract labor. Because of that, he cannot claim there is a master-servant relationship. That's what the Supreme Court has given in the judgment of Joint Secretary with the Central Board of Secondary Education versus Rajkumar Mishra in that case. Claims, gratuity claims. Any dispute where you should receive, you should raise, you have to go to the controlling authority of that gratuity act. There only we have to raise. We cannot raise section 2A ID Act. ID Act is employer-employee, some other conflict has come. That only to be raised. ID Act, this gratuity payment will not come. That's why you have to approach the proper authority. That's what given by the Madras High Court, where the Karaikal Cooperative Society Supplies Society versus Ramakrishnan case. Dry cleaning, interesting judgment. This is dry cleaning. When you receive the dirty cloths and then wash through washing machine and giving back to the customer, whether that unit will become a factory or not. When you want to decide whether that place is factory or not, there are two things you have to see. One is 10 manpower with power, 20 manpower without power. That is the one criteria. Another criteria is whether it comes under manufacturing process or not. Manufacturing process, factories are clearly defined what are all the things covered under manufacturing process. Washing and cleaning is covered under manufacturing process. That definition is clearly says. When the dry cleaning unit you are running with sufficient manpower, what it will clean, you are cleaning, washing the cloths, including there is a, would be squarely covered by the expression. That covered, the expression is clearly covers manufacturing process. That's why that will be treated as a factory. That is a judgment given by Supreme Court of India. Sexual harassment, posh compliance. In that one interesting judgment has come. One male employee seeing the female employee is commenting on the long hair of the female employee. Whether that will be treated as a sexual harassment or not. Normally when you see, yes, it is a sexual harassment, no doubt in that it will be treated. In case that he is commenting on the body parts, definitely that will be treated as a posh, that is sexual harassment only. But here, Bombay High Court has given, no, that is not a sexual harassment. How? They have justified very efficient way. Because when the 4 or 5 employees are there, one female employee, the male employee is commenting on the hair, your hair is very long, through JCP only you have to comb your hair, like that he is commenting. The girl given the judgment, IC also taken that is a sexual harassment only, but court has commented it is not a sexual harassment because it has been established by after the comment, there is a cordial relationship through WhatsApp, it has been established. They were talking, they were appreciating, they were instructing, many things happened after this comment. That shows it is not in the intent of sexual harassment that comment has been passed. As well as another thing has come in this judgment, all known thing only. When the male employee is commenting or sexual comment on the male employee, male to male. So your mission has kharab ho gaya kya? Like that he has commented another male employee. Whether that will comes under sexual harassment or not, that is it has taken by ICC, but it has court has given judgment. It is not sexual harassment, comes under POSH. So you have to take action according to the rules or standing orders of the company, but it is not comes under POSH, because this POSH is especially for women employee, not for the male employee. That's what the judgment has given. DA points, this for Tamil Nadu, March 2025, 338 points are there. Anything variable DA, if you are calculating, it may be useful. Hope this video might be useful for you. Please share to HR fraternities. Any doubts, any thing on this video also, you can comment, or you can send SMS or WhatsApp to us. We are happy to serve you. Thank you for watching. We'll get back with another video. Thank you.